this subcommittee. Also, as Megan stated, my trusted co-chair is on a much needed vacation. But if you all know Jerry, she's probably somewhere working, and she's also responsible for preparing the minutes that you have today. If we could all go around and just introduce ourselves, starting with Nancy. I'm going to call your names by how you appear on my screen.
Okay. I'm Nancy Turner. I'm on the Board of Pardons and Paroles.
Chief Rosado.
Good morning, Rob Rosado, Chief of Police in Meriden, also President of CPCA. Thank you.
Ms. DeCara.
Yes, Phyllis DeCara, attorney in Rocky Hill and a member of this committee and the full committee.
Mary.
Good morning, Mary Kazicki, Office of Victim Services with the Connecticut Judicial Branch.
And Judge Doyle.
Kevin Doyle with Connecticut Judicial Branch in Hartford.
Attorney Tyler.
Good morning, Nancy Tyler. I am an attorney in Hartford, and I am a survivor representative to this committee appointed by CCADV.
CJ.
Afternoon, everybody. CJ Force here with Judicial Family Services Regional Manager. Good to see everybody.
Andrea.
Good morning, everyone. Andrea O'Connor. I'm the Family Violence Victim Advocate Program Manager for the Umbrella Center for Domestic Violence Services. I supervise the court-based victim advocates in Milford, Derby, and New Haven.
And Megan.
Good morning, everybody. My name is Megan Scanlon. I'm the president and CEO at CCADV. I'm also the note taker, so sorry if I'm like looking down and I'm taking notes too today. And I think we have everybody. Did we get everybody?
No, Joe.
Oh, Joe, sorry. I didn't mean to do that, Joe.
Yeah, I'm very forgettable. I'm Joe DeTuno. I'm the Director of Family Services, part of the Judicial Branch of Connecticut.
And Captain LaRock.
Good morning. Good to see everybody. Heather LaRock. I'm a captain with the Windsor Police Department.
Again, welcome everyone. Has everyone had an opportunity to review the minutes of the last meeting? They were forwarded to me by the forever working Jerry Wild. Has everyone had an opportunity to review them? And if so, I will entertain a motion.
So moved.
Is there a second?
I'll second.
Are there any corrections?
Sorry, who did the second? There were two.
I believe it was Nancy.
Okay.
Tyler.
Yep.
Are there any corrections, additions, deletions? All in favor?
Aye.
Aye.
Any opposed? Motion carries. The minutes are approved. If I could go to our agenda for this morning, I believe next week at the larger committee meeting or the larger council meeting, there will be a presentation from Darren Mitchell on Connecticut's opportunities to enhance or to enhance its firearms compliance orders. So Jerry and I discussed that maybe for today's meeting, we can sort of get the conversation started about Connecticut's firearms monitoring, the enforcement as it relates to domestic violence and victim safety. At last month's meeting, we delved into an area of the arrest warrants from the starting point of a complaint, the drafting of an arrest warrant, reviewed by a prosecutor, signing by a judge, and then executing the warrant. What I'd like to start with is Captain LaRock, if she's willing. In those cases where an officer is dispatched to a domestic violence call and the caller has reported that guns were displayed or used, or that there are guns in the house, what actions are your officers required to take? Maybe Chief Rosado can jump in on this as well.
So it's dependent on, so having guns in the house and displaying them are two vastly different things, which require different responses dependent upon what the complaint is, the domestic complaint, right? Is it a verbal argument and there happens to be guns in a safe in the house, but there were no threats of violence made, and it turns out that it's not an arrestable type of response? We're not required to really do anything if we feel as officers that the situation has been mediated to a point where everybody is safe and everybody's expressing that they feel safe. Right? There's not a legal requirement there. If it's not an arrestable offense, we're going to a disturbance. Okay. However, if we go there and we know that there are guns in the house, it turns out that there was a physical, physically violent confrontation of some sort. If that person is being placed under arrest, those guns are getting seized. Now they're getting seized because they are not now, as an arrestee of domestic violence, able to legally possess firearms. Right? So if it's their guns, we're taking them. And there is it's called a compliance form.
Mm-hmm.
So we would fill out the compliance form. We'd also fill out something called a JDCR18, which is a court form for property and all of that stuff that goes along with seizures. We would take their pistol permit if they had a pistol permit as well. That gets transmitted to DESPP, Department of Emergency Services and Public Protection. They handle pistol permitting in the state of Connecticut. With a revocation request or a notification of the arrest, right, depending on the situation. So those firearms typically would be housed in our evidence room for a time until the court advised us of what they would like us to do with them, right? So that's what would happen if it's an arrestable issue and there are guns in the house that were not used as part of the crime, right? Now, if they are used as part of the domestic incident itself, if they are brandished, if there is a threat with that firearm, they're being seized now as evidence, as opposed to being seized because they can't lawfully possess them, right? So say there's one gun involved and that's getting seized as evidence. If there are additional firearms in the house, they would get seized for the other reason, right? So they get seized as non-evidentiary, like we just described. The one that is evidence then is kind of cataloged differently and handled a little bit differently, but ultimately all the guns come with us. And DESPP gets notified. The compliance statement is done for the ones that are non-evidentiary. The JDCR18 for the court is done as well, especially for the one that is evidentiary. And if we feel it necessary, we would do then a risk protection order application and all of that goes along with the peripheral, if you will, trickle down aftermath of all the paperwork that gets done. But that's in a nutshell. A couple of gun seizures 101, Chief. Have I forgotten anything?
No, I wanted to highlight the risk protective order because sometimes there may be a case where there's not an arrestable offense, but it may rise to the level of a risk protective order because there's an underlying factor such as mental health. And if there's a concern for the safety and well-being of the either parties, we would seize those weapons under a risk protective order. So thank you.
Okay. And so Heather or Captain LaRock, just to go back, so if the guns were brandished during the call that you received, those are seized on the JDCR18?
They're seized as evidence because they are part of the crime itself, right? The actual act. If there are firearms additionally in the home that were not used as part of the incident, but we know that they are there, they will be seized basically under the other procedure that I told you, but they would not be considered evidence, right?
But are all of these guns required to be reported to the state police?
The short answer is no. If you're housing long guns in your home, you don't necessarily have to report them. There's a lot of different rules that surround firearms, right? Because a pistol permit is a permit to carry a pistol on your person, right?
Mhm.
That is not a permit to have a pistol in your home for protection.
Okay.
Okay, so we might not know there are guns in the house because they might not be registered. Not that people don't register their guns, but some people don't. So we treat we're very obviously heightened in awareness when we go to any of these calls, and we are very particular in asking, do you know if there are any guns in the house? Because it might not come up when we run them, right? But that's always something that we're going to ask the people that are present as part of our investigation.
Lieutenant Maynard, do you want to jump in, or is there anything that was missed?
No, I do apologize. I missed the beginning of it. I caught the tail end. But yeah, I would just add that again, like, yeah, the actual firearms piece, as Captain LaRock was mentioning, can become a little convoluted and a little more of its own conversation, separate of the orders of protection, as far as from a licensing and firearms versus what's registered, what we're tracking, and then what people actually have.
Okay. Megan or any of the advocates or anyone else, do you have any questions regarding this process?
Gail, it's CJ Forster, Howard. I just got a quick question, maybe for law enforcement, just so I'm clear. The firearm is not used in the incident, but you're talking about a provision that allows you to take that. There's something prior to the imposition of a protective order that would allow you to take that firearm before they're presented in court, even though it wasn't used in the crime.
There is.
Correct? Really?
They're called conditions of release. So
okay.
Yeah, so conditions of release are that stopgap for the time of release to the time of arraignment. So it's that temporary protective order, if you will, that covers that span of time. That conditions of release does not allow a person to carry or possess firearms during that period of time, just like a protective order. So if a person is getting released on a family violence crime, their guns are getting seized.
Anyone else? Nancy?
I'm interested in situations where the individuals involved aren't cohabitating, so the guns may be in another location.
So in that case, we could also apply for a search warrant for those locations if we don't obtain consent to search. Oftentimes, firearms are removed from the home of the individual and placed somewhere else. And hopefully we learn that during the investigation, and hopefully we get consent cooperation. If not, we would get a search warrant to seize those weapons.
I have a question, and this may be a subject for another day, but how quickly can they get them back if they've been seized under those kinds of conditions?
It's dependent upon how long the order is standing, right? Because for the duration of that order, they can't possess firearms. And so if the order lasts for just the adjudication of the case, well, maybe that's the time frame. But it really is dependent on what a judge decides is appropriate and safe, right? Ultimately. But they cannot possess them in any way, shape, or form while a protective order is in existence.
Okay, thank you.
So I think what we probably should do is sort of jump to,
Sorry, Gail. Can I ask one other question to this? So let's say you go to a call and there isn't an arrestable offense. I'm just curious as to how, but you know the guns are there. I'm curious as to how the safe storage law plays into this. Like, are you checking for safe storage, even if there's not another arrestable offense? Like, how is that? Because that to me is also part of this process. And I know it was passed for very different reasons, but very much linked to safety of survivors and their children. So I'm just curious as to how that plays into this, since it's a newer law, and what the process is.
So for the Meriden Police Department, what we do is on any gun call, if there's a situation where there's a possible firearm present in the home, we would have the officers go in there and inspect to make sure it's actually stored properly. So our officers go in there on many different cases, not just domestic violence cases. We have incidents where kids report at school that the parents have a gun. We just want to make sure that the parents are safely putting these guns away. So we always inspect it with the parents. We go inside the home, make sure everything is safe, and then we report it. We make a documented report of it.
And so if it's not stored safely, is that now an arrestable offense?
It could be. Oftentimes, we also give them locking mechanisms. We provide them with, we have a lot of kits here at the police department. We always bring that with us to make sure that if they don't have one available to them, we make sure that they have a locking mechanism in their home. But most of I haven't found one that hasn't been stored incorrectly here in Meriden.
So in those cases where you're responding to a domestic violence call and it is an arrestable offense, you arrest the person, they're instructed to go to court the following day, and a judge enters a protective order that prohibits that person from possessing any firearms. What's your process at that point? And this question's to law enforcement. Heather?
Well, it depends on whether we've already taken the guns.
Okay.
Right? Because we have that, we don't have to wait for the judge to issue a protective order. As a matter of fact, we issue, like I said, that temporary, if you will, it's called conditions of release. So when an arrestee is released on domestic violence charges, they are given at the time of their release this order put in place, this temporary order that will automatically become null and void when that official, if you will, protective order is entered after arraignment. So it's, like I said, it's that stopgap for that, just that period of time to ensure that there is an order in place to protect the victim. So if we can gain compliance that night, should there not be exigency, we might not, if they're not living in the same house, if they're not, it depends on circumstances, right? If there's no need for us to go in there and seize all the guns that night, then the compliance statement is usually presented to the person and say, listen, we need to collect your guns. You need to present your guns to the PD. It's a lot of times situational, right? Because not every domestic violence incident rises to that level, right? Some of it's verbal threats. Some of it really is just situational. If we feel as officers, though, that there is the slightest bit of risk, at least I can speak for us, then we're going to take them that night, right? That's just better safe than sorry in these situations. So that can take the form of a couple of different things, right? It could be, yes, during the course of that incident, as we're responding and processing that person, we are also completing that compliance statement and taking those guns and taking the permit if he has one, she has one, and taking care of all of that. Or that same process could happen the next day. We oftentimes will get requests from state police for someone who is arrested by them on a domestic violence incident that maybe didn't happen in our town, but happened elsewhere where they respond. And we'll get a letter that says, hey, here's our compliance statement. This person is now party to a protective order. Can you please respond to your resident's house and take those guns and complete this compliance statement? So it really can take a lot of different forms, the way that that process looks.
Okay. And I know that I think it was about 2 years ago that Jerry Brianna Maurice from State Police and and maybe CJ or Joe sort of got together to try to ensure that, or to try to determine if there were ways that we could determine compliance or ensure that those persons who were ordered to surrender their firearms had actually surrendered those firearms. Do you come across cases where people who were ordered pursuant to a court order where they haven't actually turned over the firearms as required. Victims advocates, do you come across cases during arraignments where people who may have had a protective order come in with a new arrest and it shows that they were in possession of a firearm? Andrea or Joe?
We do have that where if someone was arrested on a separate crime and it was a gun charge and there was a protective order in effect, they will also violate the protective order. So it would come in as like a sort of domestic because it was a technical violation for having the gun. And we do notify the victims in that instance, because even if it is a gun case, we do want to let them know that they were in possession of a firearm, because that is a huge safety risk. So whether it was a separate crime or within a secondary domestic, we are notifying the victims of that arrest, as long as it comes through family relations and us, because we do need to be made aware of it, of course. But we are letting the victims know, because it is a big safety concern for clients if someone was in possession of a gun and not supposed to be because of that protective order.
And like in Andrea's case, you're in New Haven, correct?
Yes.
So, in New Haven, and I know in Hartford, where they have DV dockets, but they also have gun courts.
Gun dockets, yeah.
So, how do your courts, Judge Doyle and Andrea, how do you guys handle that situation where a person is subject to a protective order, yet they come in on an unrelated charge where they're alleged to have been in possession of a handgun? Say it's a pistol without a permit. A person had a gun on their person when stopped by police. Now, again, you have a domestic violence docket and you have a gun court. Where do those files go?
For us, they would go to the gun courtroom. So usually domestic violence would be the identifier. So if they have like a motor vehicle and a DV, or a drug and a DV, the DV court would take control and all their files would go there. But if there is a gun involved, that would actually go to our gun docket in New Haven. But my office would still monitor those files. And we still have, access to the prosecutor, access to the courtroom. We're still notified of offers, things like that. And we also in New Haven, because of the gun docket, we also get transfers from Meriden that are gun files. So if there is a DV with it as well, we actually take on that file as a transfer and keep the victim updated.
Is that the same process in Hartford, Judge Doyle?
Yeah, I believe it is that the gun docket generally takes precedence. The only thing where it might be somewhat different, I'll check to make sure with our family court judge now that's doing it, is if they're in the middle of a program where they're in treatment, say doing Evolve or Explore, that file may still stay there. Obviously, that could be a violation and that may get them terminated from the program. But that's the only thing I just want to leave out as a potential where if it's already heavily involved in the domestic violence docket, it may not necessarily get moved. But I'll find out about that.
So in those cases where the new unrelated charge is much more serious, say they use that gun and injured someone. So, it's an assault 1 or an assault 2, where generally our DV cases are on a Part B docket. And now you have a much more serious case that comes in that results in that new file being transferred to Part A. What happens to that DV case that was in Part B?
For us, most of the time, it will be transferred to Part A with the controlling file for a global resolution. For New Haven, they usually put it on what we call the Y docket, which is cases that are from the GA, but they're tracking with Part A files. But they're officially considered transferred.
And Judge Doyle?
Yeah, we have the benefit, we're all in the same building as opposed to New Haven where the GA and the Part A are two different buildings. So generally the Part A will take precedence. The other files we refer to as tracking dockets, they'll go on our A docket and they'll track the Part A cases and the judge will be aware of them. And if there's anything going on there's something related to that case, the judge will handle it in the context of the Part A case.
Megan, do your member agencies have any concerns that, when something like that happens, when an abuser picks up a new case that's unrelated that involves a firearm, are there any concerns that the DV file is not given the attention that you think it deserves?
I mean, I defer to Andrea because she lives this, but I think it varies court to court. I think that's part of it, is it really depends on which court you're in and which advocates. It's all relationship, it's like what advocates have the strong relationships with the prosecutors that are involved and the judges. So I think that's part of it, is it just varies across the state. So I think that's the biggest challenge, is that it'll vary depending on what GA you're in. I don't know if Andrea, you wanted to add anything, but that's kind of like, for all members, that's the feedback that we hear across the state, that I think the frustration lies in that it varies so widely.
It definitely varies. And for us too, the victim position, varies. Some victims feel strongly when, someone's been arrested for an unrelated crime. And then we have other victims who may have been supportive of the offender and say, well, that has nothing to do with me. So it also depends on the victim position, as well as, the prosecutor handling the case, what GA you're in. If our cases get transferred to Part A, the OVS advocate kind of takes those over because she has more information, has the file, has that prosecutor's ear. So we have a great relationship with our OVS advocate in A, Christy, who's amazing, and we collaborate when our cases are transferred there.
Nancy, did you have a question? Nancy Turner?
I was interested in going back to the question you raised about surrender. And if there are timeframes that are established for the individual to surrender the firearms to the police department, what's the follow-up, as you were pointing out, if they fail to do so? And are there any other consequences?
So I could answer that. We had a couple incidents here in Meriden in the last 4 years where individuals weren't compliant after given the protective order and the domestic violence arrest, not surrendering the weapon. So we went back and did an arrest warrant for the individuals to be arrested, and we moved pretty quickly. We don't waste any time. I'm sure that's across the state. Law enforcement takes us seriously, and we certainly, if we don't gain compliance, in one of the cases, the individual didn't know where he had placed it. We believed he was lying, so we ended up doing an arrest warrant for that individual. And courts, the Meriden courts at least, took it serious and have been taking this case seriously.
Heather, did you want to jump in, or?
I don't really have anything additional above and beyond what Chief just said to add. I mean, we see similar things here, and that's how we take action. Like, firearms calls for us are one of those top priorities. So if there's a gun involved, especially if there is previous violence with the individual. That's going to take top of the stack, and we're going to take that one first.
So Chief Rosado, how did you find out that the abuser or the offender was in possession of firearms?
So one in particular had weapons registered to him. We seized most of them, but one wasn't located at the home. And we were trying to figure out where that other one was. Eventually, we got compliance, we got an arrest warrant. We got compliance after the second arrest warrant, but we made an arrest for the violation, the criminal possession of the firearm after the arrest for the initial domestic violence. We saw that on his file, that there was a weapon registered to him, and we didn't locate that one. So we went back and obviously some help from the victim. The victim helped us out. She was cooperative. She showed us information that he was aware of where the weapon was.
Mm. And Megan, I'm not sure if you're aware of this, but a few weeks ago, Jerry asked if I thought that maybe the courts could add some sort of procedure in the interim for those cases where victims want to be sure that the offender has surrendered all guns or all firearms. She drew an analogy to those cases that are monitored by probation, where you can have the offender, while his case is pending, come in, submit to urinalysis screening or some other measures to show that that person is complying with court orders. And she asked me if I thought that the courts would be willing to entertain either some sort of continuance on a docket where that person comes in and states that, yes, I'm still in compliance with the order. I said I didn't know what that would look like. I didn't know how that person would get into court. Usually, unless it is a violation of a condition of either a probation or a condition of release, we don't really have a way of getting that person into court. Is this something that you guys have talked about either in discussion with victims or your own staff?
Yeah, I think the goal, what we, I think, have been trying to figure out is how do you really verify? So we safety plan right now, and we just tell everybody, assume that there's guns, right? Which is it's not a horrible way to safety plan, but it's also not ideal. I think we have individuals that would really like to know, were the guns seized or not? And I think that gives them a little bit more peace of mind than having to work with an advocate and the advocate saying, okay, well, let's just safety plan based on the fact that we should just assume that this individual has guns. So I think what we were trying to get to was just an affirmative on the record that this is check done, right? And so it sounds like there's different processes for different systems, but how do you get, it sounds like Chief Rosado and other departments are going out for the arrest warrant if they haven't complied. But there's also 169 different police departments, so we only have a couple on here. So unless we are to kind of go out to all 169 towns and say, hey, are you doing it the same way that Merritt, the two Captain LaRock and Chief Rosado are doing it, which maybe in the majority of cases they are, but I think the issue, it keeps coming for us to consistency across the state. And I think that's what we're trying to figure out is what could we put in place that would bring some consistency to the process. So that, I don't know if it's an administrative fix, Gail, on your end, where it's like a, you create like another checkbox on a form. Like, I don't know what it should look like from the prosecutor's perspective, but I think that's what we were trying to figure out is there a way to on the record confirm that this part is done? And if it's not done, is it the prosecutor going back to law enforcement and saying, hey, I don't have anything on the record here that these guns were seized, like, can you go back out? Like, I think just getting to a place where that's being done consistently across the state. And Andrea, I don't know if you have thoughts on this too, because you obviously hear from your fellow court advocates as well.
I mean, it is definitely a concern of clients where they don't know. We tell them, oh, they can't have guns, and they're told to, surrender them. But do we actually know if they were turned over? A lot of times we can confirm, oh, they were seized that night, but sometimes that doesn't occur. And there are a lot of clients that are concerned, did the person turn them over? Do we have confirmation of that? And I think it would be a sense of relief for them to know that they don't have any of their guns and that they were in fact surrendered. Of course, we then get to the other issue of, they have illegal guns. So that's, a separate issue. So of course we're still, safety planning around, around the weapon itself. But, those situations where there are registered, it would be a great relief to know if there was a way to confirm, for the clients that they were actually seized.
One other aspect just to add to make it more difficult is I know periodically I've had people say to me, geez, why can't you judges fix this? You judges should be able to step in and require them to answer on the record whether they turn their guns over or not. And I get it. And I understand the frustration, especially coming from victims of domestic violence, why they would want that to happen. But we are also kind of limited by the Constitution. And every person who is arrested and charged has a right not to be forced to incriminate yourself. And that prevents us from having a system in place where we're going to individually question each defendant, say a week after their appearance or a month after their appearance, did you turn over your guns? Because at that point, anyone who has a lawyer, okay, whether it's a public defender or a private lawyer, is going to say, Judge, my client's not going to answer that. So that the only people that we would technically even get answers from are unrepresented people who don't know any better. And that wouldn't be fair or right. So I just want people to understand that we understand their frustration, but we are limited by our Constitution and our rules of what we can and can't do. So we have to kind of work within that environment. And I just want people to be aware of that.
So can I ask a follow-up? So can you in the gun docket have that conversation? Like when you meet on the gun docket, obviously it's not, you're just like meeting on the case. Is that an arena where you can have those conversations and confirm that, and then the prosecutor can go back to law enforcement? And like, I'm just wondering, like, what is the best mechanism then because I understand what you're saying. You don't want to have anybody incriminate themselves on the record, right?
Yep. So that's the problem, Megan, is generally we'd only be most people on the gun docket have a lawyer. So when we meet with them in the context of a pretrial on the gun docket, we're generally meeting with either their public defender or the private attorney. And most people that end up on the gun docket get a public defender or a private lawyer. There's very few pro se people representing themselves, as opposed to in a domestic, in our red court, which is our family domestic violence court in Hartford, there's a lot of people that are unrepresented. And they'll handle it. They'll work with family relations. They might go through the family violence education program. I would say just to, I know this for people that don't go into court, I'm trying to give them kind of a sense of, in the DV courts, maybe more than half of the people are unrepresented. And it may be 3/4. I'm sure Joe has a statistic for everything, so I should yield to him. But I would say roughly 3/4 of the people are unrepresented, and we're dealing with them with, working through family relations, a lot get resolved through our family violence education program. So you just can't really have that discussion either with a pro se. And most lawyers, if it were going back to your example on the gun docket, they may, say, look, I'll try to talk to my client, but there's no real way they can enforce it. Andrea made a good point. Some of their clients have illegal guns that they're not telling their lawyers. And, maybe a small portion have legal guns. And generally the police have gotten them in the beginning because they've run them. They've seen they have a permit. They know, and those have been dealt with. So we're trying to kind of catch the area of people that are the most difficult, either that they don't legally own a gun or they haven't registered a gun. That's where it gets really hard. I hope that helps, Megan. I'm not sure if I talked too long.
Yeah, no, it does help. It is very helpful.
So Chief Rosado, in those cases where a firearm and ammunition compliance statement has been signed by the person who was arrested for a DV offense, is that not sufficient to ease the fears of the victims? Are you aware of the compliance statement, Andrea and Nathan? So
I was going to say, I'm aware that there is one, but if it's been, signed or not in a specific case, that's not usually knowledge that I'm given. I mean, I'm sure if I asked, the prosecutor would volunteer that. But I mean, most of the time, that's just a signature on the form to, if I'm looking at it from a victim perspective, they're going to want confirmation that those guns are out of that house. And signing a form is something, but that's not, full confirmation. Just, from a victim's perspective, I can see them say, oh, well, I can sign a form too. It doesn't mean I actually did it. So that's all.
Yeah.
Nancy? I'm sorry.
No, I was just confirming. I think that, yeah, Andrea was spot on. I think that's our challenge.
Nancy Turner, did you have a question?
I wanted to go back to what the captain said about the different circumstances in responding to a domestic violence call in which guns are taken. Is there any provision for a victim to ask the responding officers to take guns out of the house for safekeeping?
If it's their guns, then absolutely. If we obviously would have to have consent from the gun owner if it's not their guns.
Are guns considered marital property if they are cohabitating and married and the guns are in the house? Does it belong to both parties?
If they're registered, they're typically registered to one party.
Okay.
So it would be, very rare that his and hers guns and shared guns. It's strange. But, we would have to have standing to take them is really what it comes down to. In some way, shape, or form, we would have to have standing to relieve someone of their property, right? In order to do that, because they have a possessory interest in their own property. So we would need to be able to articulate that there is a valid reason for us to take those guns.
And that can apply to the firearms that are not legally owned, as the judge was referring to?
Well, if a firearm isn't allowed to legally be possessed by somebody, that's a whole different violation, and that would be seized as a crime, right? Unlawful possession of a firearm. So if that person is a convicted felon or something, and they are not allowed to possess firearms, that's a whole different story. There's a lot of different circumstances under which firearms could be seized. So the nuances are kind of hard to explain if you're not in the business, I guess.
And I want to go back to what I said, and I appreciate the answer about the conditions of release. And again, it's been a while since I've been in the field, but a non-custodial arrest, there is not going to be conditions of release attached to that, correct?
There would be.
Mm-hmm. There still would be. So even a non-custodial arrest, you would put conditions of release even at the scene that they would have to do A, B, C, and D.
Correct.
Thank you.
So, Megan, in preparation for the presentation that we're going to receive next Wednesday, I believe it is, are there shortcomings that you at CCADV or your victims advocates think that maybe we could tighten up to ensure victim safety?
Well, that's a very loaded question, Gail. So yeah, I think from our perspective, I think we just want consistency in a process, right? I think what we experience, and Andrea, you can chime in, and I'm trying to generalize this for the entire state, is that there's just inconsistency. So sometimes a GA will say this is on law enforcement, and law enforcement will then turn around and say, no, this is on the GA. So I think I think that's where the frustration lies, is like, we completely understand that that there are so many different systems to ensuring individual safety in this particular topic. And we get that. But I think when it comes to having to work with victims and trying to explain this, like, we just don't get a consistent approach. So it sounds like from the folks we have here in terms of representing law enforcement, they have similar processes. At least that's what I'm getting through my note taking. But, you know, this is like a very small subset, right? So if we go to Bridgeport, or if we go, you know, to, Vernon, like Rockville, any other, I think that's the biggest thing, is like, how do you get consistency across the state so that we have consistent outcomes and we are getting to a place where we feel like we're keeping victims safer and their families safer. I think that's the struggle, is we have no way to really confirm for them that they no longer have these weapons. We have no way across the state to consistently say this is the process. And part of that could be like, we have, Hartford and New Haven that have gun dockets and have a semblance of DV dockets. And so maybe part of it is the fact that we just don't have consistent dockets across the state. I mean, there's a lot of different ways I feel like this discussion could go. So I think the point of the presentation is to bring in, a different perspective that's sort of been able to look at this across the country and just really bring to us what has worked really well in other states and how we might be able to apply it. Knowing that one of our challenges, and I just came from a national conference last week, and everybody is blown away that we don't have counties. They're like, what? Like, so that a lot of this maybe is consistent across other states because they have different government set up. I mean, I think there's a way to apply it in Connecticut, but I think we're going to have to work through it in a different way, because we're obviously not bringing back county government, right? So I think it's just that bigger strategic issue. And Andrea, I don't know if you wanted to add or talk about how that like feels on the victim side, but it doesn't feel great.
Yeah, I mean, I was going to say, you said it perfectly. I mean, inconsistency is definitely the biggest frustration. I mean, I supervise 3 different courthouses and things are different in all 3 courthouses. So I've got some advocates dealing with, the same issue in a different way. And that goes for, all sorts of things throughout the process. But there are victims who have cases in multiple jurisdictions, and the fact that it's different in every place. I mean, the criminal court process is already a difficult and traumatizing place for a victim, but when you have to go through a different process in every single court, or the decision is being made differently in every single court, it's incredibly frustrating to go through, and a lot of victims don't feel heard through that process because every court is handling it differently. So it's definitely incredibly frustrating for them. And like I said, I supervise 3 courthouses that are very close together, and they handle things, completely differently. So standardization would be extremely helpful.
Joe, do you know how often it is that persons who are prohibited from carrying firearms as a result of a protective order actually come in with new charges for having possessed firearms?
I think it'd be kind of hard to call that out because it would probably be, it could be a violation of protective order. It could be additional gun charges. I don't know the answer. CJ, do you have an idea of the volume? I think from our perspective, from family services, we're charged with letting the court know if the victim indicates the offender or the defendant has a weapon or a permit, and the victim, obviously, if the victim says the person has a gun or a permit, we let the court know. So a lot of what we do is just alerting, and then there's a process thereafter that, I think that the state police, I know Jerry Wild and CJ and I with a bunch of professionals sat around and tried to figure out kind of how does this all work from a state police perspective, which I think was just challenging because I think that at some point the protective order gets to a place where the state police understand that who shouldn't be having a gun, and then it just becomes difficult at that point for enforcement. But CJ, do you have anything else you'd like to add to that? I think we went around pretty dramatically, but it felt like to us that there is a mechanism where someone at a state police level has the information that somebody didn't turn over a firearm, and then how does that then get to revert back to the court to kind of deal with that issue? So I think that's where we struggled.
And how long does that take? Like, how long does it take for the state police to get notified?
I think it's not very long. I think it's a pretty, my understanding, and this was I think we met even before COVID, it was a pretty tight system, right? Where they get information about somebody no longer is able to possess a firearm because of the protective order. And then from there, it just becomes, who enforces that? And that was the challenge.
Right. So is it going to the local police department?
And again, I'm no expert in this, Meg. I'll be honest. My understanding is that there is some form of notification. I just don't know how that all works. And I think that's really where our struggle was, is that there's information that is gathered, but then it becomes who actually deals with that issue, like whose responsibility it becomes. And I think that's where, Jerry, when we kind of tried to figure this out, there really wasn't a great outcome or an answer to the problem, which is somebody has that information. And how do we then make sure that that person gets held accountable for having a weapon that they're not supposed to have? CJ, do you have anything else to add? I know you were in those meetings.
No, like I said, I think we met last time. Again, I'd renew my suggestion that I think Joe went on, and I can't remember the name, they came from the state police and did that presentation. And they, Megan, some of those kind of basic kind of questions, they were able to kind of provide, and, the cross-reference and how soon it goes in and what they do with that. It was really helpful for me. And I think you're right, that was 4 or 5 years ago. So again, I would renew my suggestion that maybe, again, that's a place to start to see what exactly that process looks when somebody has a legally registered firearm, and what the intersection between the state police and the local police. And again, getting back to Andrea's point, I think, again, my experience is on the gun dockets is the vast majority of those violations were not people that had a legal right to kind of own them. And again, Andrea, you can kind of speak to it again. My time in New Haven, the vast majority of those, that wasn't the situation where they were being arrested for not simply turning it in. They picked up a subsequent charge because they had a firearm. So again, my suggestion again would be twofold: is that, and again, somebody, Joe, you could probably remember, was it Bree? Where was she? Their name from the state police?
Brianna.
Brianna, absolutely. Very, very helpful for myself, who's even been in the field for a long time, just to see what exactly they do, and also sharing some of the frustrations when people, legally have a right to possess, and that kind of conduit of how that information gets back and forth. It was helpful for me, so I would kind of renew that suggestion to the subcommittee that maybe that's something we think about inviting them back in to kind of do a short presentation for us.
Yeah. Lieutenant Maynard, do you have any insight into this?
So I would say the same as far as on the backside. So Sergeant Maurice, Brianna Maurice, is still over at SLFU, so the Special Licensing and Firearms. And as far as any of the paperwork, that firearms compliance statement that we talked about, that they do get the notification, and whether they have the 24 hours from upon receipt of that, where the police department is also going out, as well as having something mailed to them. I would say her or a representative from over there is going to be best suited to speak about what that looks like after that, because that's kind of after the law enforcement has had its piece, and then what's happening with the processing and where that all goes.
Okay. So there isn't really like a clear, like, after state police, it goes here.
I can't speak to that side from so that would be that unit would specifically handle that. So I know what the troops and like the patrol base is basically doing with that, but I can't say what they're doing with it from that point at headquarters going over.
Okay, got it.
I think there is knowledge, right? There is information about who hasn't done what they were supposed to do. The question then becomes, how do you, whose domain is it in, right? To follow up. And because I know there were some challenges in I'm getting older, but I think some of the challenges they had was the inability to actually go into an offender's home. And search it. I think there was an issue with that. If CJ, am I right on that? So
Yeah,
there was
you are absolutely correct. I mean,
a lot of barriers.
that was some of the frustrations they shared. Yeah.
Nancy, did you have a question?
No, I'm just trying to digest all of it. So when it comes to surrender, what kind of numbers are we talking about versus seizure?
Do any, maybe state police, do you have any idea, even from the presentation that you gave a couple of months ago?
Again, I would defer over to SLFU, because they would actually be the unit that houses all those numbers and would be responsible for pushing any of that up for reporting. So I do believe that would be there, but some of these questions are probably better suited for the licensing and firearms unit, just relative to the processing, the tracking, where things are going from there, and then the actual statistics.
All right. Okay. So I haven't.
She was an excellent. She was excellent. She gave a lot of information, and it really did provide some clarity for us, but not necessarily a solution to the difficulty.
Problem. Okay.
But I think that'd be good to because that was really before COVID. I think to have her back to just give the subcommittee an idea of actually what they do and where their challenges lie in terms of enforcement, that would be very helpful. I think to refresh our memories, but also put us to a path of any way you slice this, they're going to be the entity that needs to be part of this solution anyway. Whether they can fix this problem or someone else has to kind of deal with it, they're still going to be really a essential part of it.
Okay. I have that as an action item for the committee.
So actually, I think, as a result of this conversation, that I'm very interested in hearing what our presenter will have to say next week regarding how they're handling compliance in other parts of the country. Are there any other comments or questions on this topic?
At a minimum, maybe Bree could just give us a short, maybe she has a document or something that we can review so that we kind of have some, for me, it'd be a refresher, but for others, just an information. So we have that before we hear from other states, because if we don't know what Connecticut is doing, it's going to be hard for us to compare. So it would be very helpful. Although I'll be in Aruba and I won't be at unfortunately, I won't be at the thing, but I think it'd be really helpful to have Bree, if she's able to, just give a short kind of maybe even an outline of what happens. I think that would be very important.
Okay.
Okay, Megan, maybe we can get in touch with her.
Yeah, I have that as a note to follow up. I can ask to follow up. Sorry, I'm doing the minutes and but
Well, thank you for that.
yep, I got the follow-ups, so we're good.
So, moving along on our agenda, updates and other business. Are there any updates or other business?
I have quick other business. I'd just like to congratulate Chief Rosado as being sworn in last week as the Connecticut Police Chiefs Association president. I would also like to congratulate Captain Maynard on his recent promotion.
Oh, congratulations.
Thank you.
That's awesome.
And I think Jerry has asked that we set up a meeting schedule for the rest of this year. And one of the questions that she asked is whether we are taking July and August off. I don't know if we're allowed to, Megan.
So that's a great question. So, well, the full committee has to meet a certain amount of times every year, but the subcommittees can set their own schedules. So ideally you're meeting prior to the meetings, but if I don't know that we have an August meeting scheduled, I think we have a July meeting for the full council scheduled, but I don't think we have an August at the moment.
Okay, so does that mean that we have to meet in July also? Well, we might, I guess, if we have a
It
full
might make sense
council
to
meeting.
meet after the presentation while it's still fresh in people's
Yeah.
mind. So I would suggest at least meeting in the July. I know July is tough because July and August become very challenging, but I think given that presentation will happen next Wednesday, it might make sense to meet to be able to kind of like debrief on that and what people's takeaways were and what we want to look further into, or if there's certain states that we thought had interesting best practices. So I do think it would make sense to meet in July. And then defer to the group on August. Don't ask Jerry and I, because we would always meet, and it's not helpful.
So, do we have a consensus on whether or not we want to take August off? Show of hands.
Aye.
I'm okay with
Okay. I think the ayes have it. No meeting in August. And we'll pick back up in September with our regularly scheduled meeting. I think our meetings are usually on Wednesdays, correct? And it's because of tomorrow being a holiday that this meeting is on Tuesday. So is that the third Wednesday of every month?
it is, let's see. Yeah, you're right now. You're set as the third Wednesday of every month.
Okay,
So it would be July 17th.
okay. Okay, July 17th will be our next meeting at 11 o'clock. I'm not sure whether or not that's going to be a hybrid meeting or not, but I'll hear more when Jerry returns, and We're gonna take August off, and then when Jerry returns, we'll set the schedule for September through December. Everyone in agreement with that?
Yes.
Okay. Is there any other business? Is there a motion to adjourn? Second? I believe that was Chief Rosado, Megan.
I
I'll
got
make the motion.
Second.
So everyone enjoy your day off tomorrow, and I guess we'll see you next Wednesday. So thank you all for joining today.
Thanks, everybody.
Thank you.